I now call the meeting of the Code Enforcement Special Magistrate to order. Welcome to Hillsborough County Code Enforcement Department of Consumer and Veteran Services Special Magistrate hearing. When addressing the Special Magistrate, please state your name, address, and speak clearly into the microphone. If you are planning to speak during this hearing, you must sign the speakers list located at the front door so your case can be called. I would like to introduce the staff present on the dais. Sonia O. Rodriguez, Manager, Citizen Board Support. I am Dr. Thomas Santarlis, the Special Magistrate, appointed by the Board of County Commissioners. Paul Johnston is a Senior Assistant County Attorney, and Michael Streeter is the Recording Secretary. The basic process for this hearing is as follows. Ms. Rodriguez will conduct the oath of witness. Your case will be announced. Officers will present their evidence on your case. You will be allowed to rebut that evidence and explain what has occurred. I will close the hearing and announce a decision. I may ask questions and allow other witness testimony. If you have not complied by paying the past due citation penalty fine, including any administrative costs assessed, and correcting the original violation within the time ordered, you will receive a notice in the mail. By law, you have 10 days to contest that notice. Otherwise, it will be considered correct and your license, certificate, or permit may be suspended. Per each ordinance under Trespass Towing Section 50-192, subsection B, and Vehicle for Hire, Section 10-594, subsection B, persons violating these ordinances may be subjected to prosecution in the name of the state of Florida in the same manner as misdemeanors. By law, you also have 30 days from the date of my order to appeal my decision to the Circuit Court under Florida Statute 162.11. Any person who decides to appeal the Special Magistrate decision will need a record of the proceedings. The record is comprised of the testimony and evidence upon which the appeal is based. It is your responsibility to ensure that a verbatim record of the proceedings is made. By law, you have 30 days from the date of my order to appeal my decision to the Circuit Court. Presentations by the county, respondents, and opposition must be kept to a maximum of 10 minutes each. The Special Magistrate and/or hearing officer may recess at 12:30 p.m. and reconvene at 1:30 p.m. to conclude its business if needed. If you have any questions, these rules are outlined by Florida Hillsborough County Code of Ordinances and Laws, Chapter 14, Article 2, Section 14. At this time, I'll ask you to please silence all electronic devices. Could we please move to the administration of oath to witnesses?
Please stand by. Please stand by. Please stand by. Okay, go ahead.
Please stand, raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. Case is on page 2, item 1, case number RCV 2000-537, citation 00611, issuance date 6/2/2020, amount due $50. The violator A1 Recovery Incorporated. The offense date was April 21st, 2020. The prohibited conduct was failure to provide consumer disclosure on receipt. Location 11517 Perfect Place, Tampa, Florida. The investigator is Cindy Anderson. Is anyone here for this case? Please step forward. Please state your name and address for the record.
Jason Goldstein, 7601 38th Avenue North, St. Petersburg, Florida, 33710, attorney for the defendant.
Aaron Watkins, A1 Recovery, 381 Roberts Road, Oldsmar, Florida, 34677.
Good morning, fellas.
Point.
Good morning, Dr. Santarlis.
Good
This is
morning.
Cindy Anderson, Regulatory Compliance, 2709 East Hanna Avenue. On April 21st, 2020, while investigating a consumer complaint, it was found that the business failed to provide Hillsborough County Consumer Protection regulatory compliance information on the written receipt. This is a violation of Section 5181M6. The last page of the PowerPoint, it shows the tow invoice, the original tow invoice, in the back of it, showing that it's Pinellas County's consumer protection contact information. And that's all I have.
Thank you, ma'am. Mr. Goldstein?
Do you operate A1 Recovery in multiple counties?
Yes,
What counties do they operate in?
Pinellas, Pasco, and Hillsborough.
Are you required to put a notification on the back of all your receipts?
No,
What counties are you required to put them on the back of?
Pinellas and Hillsborough.
And are your employees tasked with putting those notices on the receipts?
Yes,
And on occasion, does a same employee tow a vehicle out of Pinellas and or Hillsborough County?
yes,
And was there a consumer protection notification on the back of that receipt during this case?
yes, sir.
And do you have any explanation as to why the incorrect notification was on the back of that ticket?
It's simply a clerical error. And we also have, at the A1 Recovery Oldsmar office, 3 different signs with all the consumer protection for Hillsborough County's information on there.
When you say 3 different signs, you're talking about posted at the premises?
Yes, the front door and on the gate.
Don't have anything further.
Ms. Anderson, can you please rebut?
The citation, excuse me, the tow invoice did not have it on the back of it. Initially, the consumer filed a complaint with Pinellas County. And then Pinellas County had to refer it to us. The only thing I can say is it is part of the ordinance, and they've signed with their certificate to say that they know the law or the ordinance.
So the prohibited contact occurred at 11517 Perfect Place, Tampa, Florida, and that's considered Hillsborough County, correct?
Yes, it is.
And our ordinance requires them to have this information on the receipt when operating or doing business in Hillsborough County, correct?
Yes.
Mr. Goldstein, can you please advise me why that didn't happen when your client was conducting business within Hillsborough County?
The only explanation I can offer is mitigating explanation, which my client testified to. It was a clerical error. He operates out of Pinellas and Hillsborough. They weren't trying to avoid putting a consumer on notice. It's not like the back of the ticket was blank. The driver that was tasked with giving the party a receipt accidentally used the wrong stamp that he put on the back of the receipt. I mean, we were putting the person on notice that they have the option to contact Consumer Protection. It was an honest mistake to put Pinellas County's Consumer Protection and not Hillsborough County, and it wasn't like they were trying to avoid putting someone on notice. The whole purpose of the ordinance is to put someone on notice that if they have an issue, they can contact somebody in government to fix or complain about that problem. And again, it was an honest mistake, and it was not an avoidance of the requirement to put the consumer on notice.
Mr. Goldstein, is on the back of the citation that had the contact information for Pinellas County. Is that why the consumer made a complaint with Pinellas County as opposed to Hillsborough County?
I don't have any information that the consumer made any complaint, and I object to any information along those lines as being hearsay because the consumer is not here to testify, nor have I been able to cross-examine any consumer.
Agreed. Ms. Anderson,
Yes,
is
sir.
it possible that it was a clerical error and that they put the wrong government agency on the back?
I suppose, yes, it could be. When I spoke with their representative, Diane Folk, she asked if both stamps could be put onto the citation, onto their towing receipts. I was told,
Is
yes,
there
she
anything
could.
further?
You know, this is
Anything further from either side?
obviously after the fact.
Could you repeat that, Doctor?
Yes. Is there any further testimony on either side?
No, sir.
No, Your Honor.
Okay. I tend to believe that a clerical error did occur, and based on all the testimony, I rule that the contest be upheld and that this case be dismissed. I don't believe that there was any intent to hide the information because they did stamp the back of it, and there is a possibility they could have just stamped with the wrong government agency information since they do business in both counties.
Next case is item B, case number RCV 2000-103, citation number 00661, issuance date February 13, 2020, amount due $50, violator A1 Recovery Incorporated. The offense date was November 23, 2019. The prohibited conduct is failure to cooperate with the request for information over a 2-month period. The location is 9540 Limebar Avenue, Tampa, Florida. And the investigator is Cindy Williams.
Cindy Anderson, Regulatory
sorry, Cindy
Compliance,
Anderson.
2709 East Hanna Avenue.
Sorry.
While investigating a consumer complaint, it was found that the business was contacted numerous times via email and phone. Business failed to cooperate with requests for information for over a 2-month time period. An initial email was sent to Mr. Watkins on November 26, requesting the supporting documents for the consumer complaint. In December, a phone call was made to Mr. Watkins. I did not have any response. January 6th, I sent the complaint again to Mr. Watkins with all of the attachments. On January 8th, 2020, Diane Folk, the representative from A1, sent out a explanation of the required, without the required pictures of the tow. I responded back to Ms. Folk on the 9th of January 2020, telling her that I will need the pictures to support the tow. It took another month to receive the picture, and the picture isn't, it doesn't even have identifying information on the vehicle in question, and therefore a citation was written for failure to cooperate. That is all.
Mr. Goldstein, go ahead, sir.
Did you
Hey, guys,
receive
we
an
don't have to do
email on
social
November
distancing in front of
26th
the microphone.
regarding some information regarding this violation?
We did not.
Do you recall any phone calls in December or January regarding the request for information?
I do not recall any.
Do you know if on January 6th or January 8th, you got an email to both another company named Target Towing or A1 to requesting any information?
I do not recall.
You know, who is Diane Falk?
She is my secretary.
You know if she received a request for information regarding this at any time in January?
I do not have access to her email. No, I do not.
Do you know if on January 8th, did she tell you that she received a request for information regarding this citation?
She handles all the complaints, so she would not tell me.
Mr. Goldstein and Mr. Watkins, can you reintroduce yourself for the record?
Watkins. 381 Roberts Road, Oldsmar, Florida, 34677.
All right, thank you.
Goldstein, 7601 38th Avenue North, St. Petersburg, Florida, 33710, attorney for the defendant.
Thank you.
Do you know if there was a date specific that you provided information to Hillsborough County Code Enforcement regarding this violation?
Looks like on February 13th they were.
And to the best of your knowledge, what is the first time you received a request for this information?
On the January 8th.
And you did provide the information that was requested that you had in your possession?
Yes, sir.
On July 21st, 2020, did you receive an email from the investigator investigating this specific citation, but that email may not have been related to this specific citation?
Yes.
What was that email? What was in that email?
It is from Sydney Anderson. It says, while this appears to be a tow within the ordinance, it also appears to be a predatory snatch and grab. My response back to her is, question, what do you mean by why this appears to be a tow within the ordinance? It also appears to be a predatory snatch and grab. The verbiage is being used is very offensive and I don't appreciate it. Thank you, Aaron Watkins.
Do you have any reason to believe that this investigator is harassing you in any manner?
From that email, yes.
And why do you believe that?
Apparently, she doesn't like what we do. It's obvious.
So in this email, she's telling you that you're following the tow ordinance, yet in her opinion, it's predatory.
Correct.
I don't have anything further.
Ms. Anderson,
Yes.
in reference to that email, why do you think it is predatory?
The case that he's speaking of, the consumer was a Uber Eats driver. They stopped, went upstairs, was up there maybe 5 to 6 minutes and came down. There was a witness through the whole thing. Obviously, neither of those people are here because there wasn't a citation written.
When you send out emails, do you do it by send receipt?
No, I don't.
In other words, they have to acknowledge they received it?
No, Your Honor, I don't.
Okay. Is there any type of evidence supporting your testimony that phone calls were made?
I did not bring any, no, sir.
And how many emails did you send to Mr. Watkins before he responded?
2.
And you have copies of the emails that were sent?
I do.
And did you receive any bounce backs or indication that the email failed to be delivered?
No, Your Honor, I did not.
Is it your testimony also that Mr. Watkins did reply to one of the emails?
Yes, he did.
So he was aware that there was an issue?
Yes, Your Honor, he was.
I have a question for Mr. Watkins and Mr. Goldstein, please.
Go ahead.
Okay. Mr. Watkins, is it your testimony that Diane Falk, I believe his name, is your office manager and she handles all the inquiries?
That is correct.
Okay. You're answering some questions from your attorney, Mr. Goldstein, in reference to what she does and what she may have or may not have received. Any reason why she has not come with you to testify on her own?
No, Mr. Watkins is here to testify on behalf of his company, Your Honor, and the county's evidence is that there was a response on February 13th, which was just over a month after they state that Ms. Falk responded. But there's an email here that says that Ms. Falk responded saying they didn't have a record of the ticket that they were seeking information on. So they resent the ticket. I believe 1-8 emailed, I was then forwarded to Ms. Falk, A1 recovery manager. On January 8th, Ms. Falk responded stating that she did not have the invoice. So on January 9th, the email was sent to Ms. Falk with requesting the invoice, as well as a request for supporting documents from the tow. So they provided her with the correct documentation on January 9th, and they received a response on February 13th. So I guess I'm kind of at a loss, other than a lot of harassment, as to why just over 30 days is enough time to respond to the request for information. That's
Ms.
from
Anderson, can
the
you
evidence
please,
provided by the county.
Ms. Anderson, can you please provide some more information as to the time frame?
The towing invoice was initially sent to Mr. Watkins on November 26, 2019. When the email was sent to Mr. Watkins again on January 6th, the original email was sent with that. It is also in the PowerPoint.
Okay. So the first
Ms.
email
Falk
was November 26th.
Also said that she didn't receive the initial invoice, and I did send it to her, though it had already been provided to the owner of the company back in November.
All right, so November 26, 2019, the invoice was sent how? As an attachment to an email?
Mr. Watkins testified he didn't receive that, nor did he respond to that email.
Okay, I'm asking Ms. Anderson, how did you send the first invoice?
As an attachment to their business email, as well as the email that I have corresponded with Mr. Watkins for a couple years.
Okay, so that was on November 26, 2019. Then you sent a second email after the holidays on January 6, 2020. Is that correct?
Yes, sir, I did.
Torres, do you
Was
see
there a
the
third
first
email?
email?
Yes. One looks like 9,
26th.
January 9th. November 26th, okay. I'm looking at
The attachment of the invoice.
Okay, November 26th, and there was no bounce back that it didn't go through, according to Ms. Anderson's testimony.
And this is the one for January.
January 6th, so like she stated, she forwarded the original one. Was there a third email, Ms. Anderson?
Once Ms. Falk asked for the invoice, I then sent it to her.
Okay, so the third email was on January 8th.
This is
And
the
then
response from.
They
Mrs.
responded,
Falk.
what's that?
Third email was on 1/9/16 in the
Okay.
AM.
And then somebody responded with an incomplete response after January 8th. Is that correct?
She responded with an incomplete on January 8th. I then I sent her the invoice as well as sent her the very last sentence. It tells her, I will need the pictures to support the tow.
I see that. Okay. And then on February 13th, she sent you back photos, but with no ID.
Yes, Your Honor. And I made a phone call
Okay.
before for her to send this picture.
Okay. All right. Is there any further testimony on either side?
No.
No, Your Honor, other than I would like to reiterate that the November 26th email my client didn't receive, nor did the county do anything between November 26th and January 6th. What we're really talking about is between January 6th and February 13th, which is like just over 1 month.
I understand your position on that, sir. However, I don't have any corroborating evidence that that email was not delivered properly to your client. There was no bounce back, no indication that it wasn't delivered. So I have to default back to the first notification was November 26, 2019.
I'm not aware of what the county's rules and regulations are with delivery of notices, but I'm not aware that email communication is a certified method of delivery of any request for information.
Mr. Johnston, can you elaborate on that, please?
I believe our ordinance requires service of notices by first-class mail or email.
So email would be sufficient?
Yes, it does. I believe these ordinances specifically allow emails.
Okay. Any further testimony on either side?
No, Your Honor.
Mr. Goldstein?
Would there be a citation to that ordinance allowing service by email? I've never heard of service by email of a court document.
This is not a court document. This is a civil quasi-judicial hearing, and those are relaxed. I would have to go back and read through the ordinance itself to find that particular requirement, but it is, I believe it is in the ordinance.
It's a quasi-judicial proceeding that calls for the penalties and possible imprisonment for a violation. It'd be like sending someone an email ticket for speeding. There has to be some notice. If he's going to be penalized by a fine or possibly imprisonment, there has to be some verified service that he got notice that there was going to be a violation assessed against him for failure to cooperate. You heard testimony from Mr. Watkins that he did not receive the November 26th email. Nothing showing that he did receive the email.
Ms. Anderson. Ms. Anderson, are you there?
Yes, I am.
The email addresses that those were sent to, what is the email address on them?
One is info@rps-fl.com. Other one is TOKAY@tampabayrr.com. tampabay.rr.com.
And Mr. Watson, are those the email addresses for your company to be reached at?
Sir, I do not know what the first one is, but the second one, yes.
And Ms. Anderson, have you routinely emailed that company with the first address and the second address?
With the second address, yes. The first one, I believe I did a search. But I have definitely corresponded with Mr. Watkins over the past year and a half with the TOKAY at Tampa Bay Roadrunner.com.
Thank you.
Ms. Anderson, where did the first email go to on November 26th? What address?
To the TOKAY at tampabay.rr.com, as well as info at rps-fl.com.
Is there any further questions or comments on either side?
Yeah,
Ms. Anderson?
Your Honor, other than we have no idea what info at RTPS is.
Okay. It's stipulated that that may or may not be a good address for A1 Recovery Incorporated. However, Ms. Anderson has testified under oath that that first email also went to the other email address, which she has routinely sent correspondence to and have replies from. Any further comment, Mr. Goldstein?
The only thing I would add to that is even if it were assumed that Mr. Watkins got the email, there's still a response and there's still cooperation, and I'm not aware that there's any specific duration as to what is termed failure to cooperate. The email, it's admitted that the information was provided by Ms. Falk on February 13th.
Okay. All right, I rule in citation number 00661, A1 Recovery Incorporated, that based on the evidence presented, the violator has failed to pay the citation penalty fine imposed by County Ordinance Chapter 50, Article 7, Trespass Towing. I order the violator to pay the citation penalty fine of $50 plus the administrative costs of $50. The total citation penalty fine and costs of $100 must be paid within 30 days of this order. Paying the citation fine and administrative costs alone does not mean you're in compliance with Chapter 50, Article 7. You will need to correct the original violation that is noted on the citation for the issue to be resolved. Failure to comply with this order within the specific time set forth above will also result in the suspension of licenses, permits, and/or certifications. Ma'am, could you please call the third case?
Let me get that PowerPoint up. Case item number C, case number RCV 1900-708, citation number 00663, issuance date February 13, 2020, amount due $50. The violator is A1 Recovery Incorporated. The offense date was November 23, 2019. The prohibited conduct is failure to properly display signage at each driveway access. The investigator is Cindy Anderson. Sir, both of you, please state your name and address for the record.
Jason Goldstein, 7601 38th Avenue North, St. Petersburg, Florida, 33710, attorney for the defendant.
Aaron Watkins, A1 Recovery, 381 Roberts Road, Oldsmar, Florida, 34677.
Ms. Anderson, go ahead, please.
Cindy Anderson, Regulatory Compliance, 2709 East Hanna Avenue. While investigating a consumer complaint, it was found that the business did not have proper signage displayed at each driveway and access. A citation was issued. The incident happened on November 23rd, 2019. Section 50-183A1 states that notification and sign requirements for trespass tows or immobilization of vehicles located on real property. 1, the notice must be prominently displayed at each driveway access or curb cut, allowing vehicular access to the property within 25 feet of the public right-of-way line. On the fourth slide, the left photo displays, it was taken at November 25th, which is right after I received the complaint, 2019 at 4:07 p.m. You can see a crossing, children crossing but there is no signage. The picture on the right, on January 10th, 2020, no signage at that line ball entrance. The next slide. On February 13th, 2020, the proper signage has been posted at line ball entrance. Your Honor, this is the same situation, the same occurrence as the last citation. The last slide, on the left, you see the overflow parking with a van in the background. The next sign has verbiage. The next sign has nothing on the post. That was taken on January 10th. On the right side, the right picture, the parking lot where the vehicle was towed from, on February 13th, a sign has been added. It's been posted on the, it was there on the 13th. So they corrected the issue once they were issued the citation, or well, they were issued the citation afterwards because they did not have it to begin with.
Ms. Anderson, are you done with your testimony?
Yes, Your Honor.
Okay, Mr. Goldstein, go ahead, sir.
Can you state the policies and procedures of your company with regards to towing at this location?
Yes, we've had a problem with the West Chase townhomes with people ripping down the signs, so my drivers are instructed before they tow a vehicle to check the signs. If there is no signs there, then they are to put them up for 24 hours before towing.
And for this specific violation, can you tell me what happened with this tow? Did you end up refunding money?
Yes,
Why'd you refund the money?
the apartment complex or the townhome community asked me to refund the money because the guy was harassing them.
So the person who made this complaint has been given back their money for the tow.
Correct.
And the pictures aren't up there, but this set of pictures here, what does this set of pictures here depict? What's the post with no sign on the left there?
That is my post, and as you can see, somebody has torn the sign down.
So do you have signs up here?
Yes,
Do you make the best effort you can to keep the signs posted at this premises?
yes, sir.
Do you tow a vehicle out of here if any of those signs are down?
We don't tow a vehicle out of anywhere if the signs are down.
So do you have any explanation? Well, let me back up a minute. These pictures depicting no sign there, was there a car towed out of that location while there was no signage at that location?
No, sir.
I don't have anything further.
Ms. Anderson,
Yes, Your Honor.
is it possible that the sign was there when the vehicle was towed and that somebody stole the sign shortly thereafter?
There is a sign there. There is a sign post there, so that is possible. Though the line ball entrance, there's no lone pole standing there. And I went on three different times. The first time, November 25th, the second time, January 10th. And then on February 13th, they posted their sign.
So the photo that I'm looking at now is the entrance, the curve entrance to the apartment complex?
It's not a entrance to a complex. It's an entrance to a business area.
Oh, that's the previous, okay. All right, can you put the photos up from this particular case, the next set? The apartment complex. So all the photos you just showed me are for this particular case?
Honor.
Yes?
Yes, Your Honor.
So I'm trying to understand the photos on the corner, where are they in relation to this parking lot?
They're the entranceway off Linebaugh Avenue.
The entranceway to this particular apartment complex.
To that parking lot, yes, Your Honor.
Well, I see the pole where the sign is missing. That's clearly evident. It's A1 Recovery's testimony that the sign was clear and present at the time of towing, that somebody or some people removed those signs and therefore put them in non-compliance. Ms. Anderson, you testified that it would be possible for that to occur. Considering all this information, are you opposed to dismissing this case?
Your Honor, I'm not opposed to dismissing it, though the question is the signage on Linebaugh Avenue. That is not there, and then they eventually put it there once they were informed that it was against the ordinance.
So it was missing November 25th, and then it appeared on missing January 10th, and appeared on February 13th.
It was missing on November 25th, it was missing on January 10th, and then on February 13th, it was there.
Mr. Watkins, has theft of signs in this location been an ongoing problem for your company?
Unfortunately, Your Honor, theft of signs is a problem at all of our communities. They'll steal the poles, they'll steal the signs, they'll leave the poles, and they'll take the signs. They'll steal the bolts. It's an ongoing problem everywhere.
And
Metal
that's
is
a
up in price, so people are
costly problem for your company, right? Those signs are
Could you
expensive
repeat
to
that?
replace, and so that is a costly problem for your company because the signs are expensive and manpower, woman power to go out there and to replant them is kind of a cost for your company, correct?
Yes, sir.
With that said, have you made any contact with the local law enforcement agency and filed a complaint?
Many times before. We haven't recently, but we have many times before in the past. And to be honest with you, it doesn't go anywhere.
In this particular apartment complex, have you made a complaint with the law enforcement agency of that jurisdiction?
No, sir.
Are there security guards 24/7 with that apartment complex?
That I do not know.
This is a parking lot.
further
This is a parking lot. It is not a part of a community.
Oh, it's a parking lot that's not under the care, custody, control of the apartment community?
No. That's accurate.
All right, any further testimony on either side?
No, Your Honor.
No, Your Honor.
Mr. Goldstein?
No, Your Honor.
Okay. I rule that the contest be denied in citation number 00663, A1 Recovery Incorporated. Based on the evidence presented, the violator has failed to pay the citation penalty fine imposed by County Ordinance Chapter 50, Article 7, Trespass Towing. I order the violator to pay the citation penalty fine of $50 plus the administrative cost of $50. The total citation penalty fine and cost of $100 must be paid within 30 days of this order. Paying the citation fine and administrative costs alone does not mean you're in compliance with Chapter 50, Article 7. You will need to correct the original violation as noted on the citation for the issue to be resolved. Failure to comply with this order within the specific time set forth above will also result in the suspension of licenses permits, and/or certifications.
Next case is item D on page 3, case number RCV 2000-106, citation 0067, issuance date February 14, 2020, amount due $50. Violator is Target Recovery Towing. The offense date is December 18, 2019. The prohibited act is failure to accept acceptable methods of payment from the consumer. Business would not accept cash payments. The location is 14566 Seaford Circle, Tampa, Florida, and the investigator is Cindy Anderson. Please state your name and address for the record.
Aaron Watkins, sorry.
State your name and address for the record.
I thought you were going her. Jason Goldstein, 7601 38th Avenue North, St. Petersburg, Florida, 33710, attorney for the defendant.
Aaron Watkins, Target Recovery and Towing, 381 Roberts Road, Oldsmar, Florida, 34677.
Go ahead, Ms. Anderson.
Cindy Anderson, Regulatory Compliance, 2709 East Hanna Avenue. While investigating consumer complaint, it was found that the business failed to accept acceptable methods of payment from the consumer. Business would not accept a debit card, cash only. The citation 00667 was written in regard to ordinance section 50-181K3. Each towing and/or immobilization service shall staff or monitor its telephone 24/7, 24 hours a day, 7 days a week, including holidays, and shall return a vehicle and/or vessel owner or agent's telephone call within 1 hour and shall advise the owner of agent of the following. 3, the acceptable methods of payment, which shall include cash and debit cards. In addition, a towing and/or immobilization service shall accept cashier's check and money orders if it does not accept credit cards. The last slide, there's an email from Target Towing, Cal McFarland, stating that in the last paragraph, it states, customer later showed up to pick up the vehicle from impound lot where the option of cash, cashier's check, or certified check for payment. In the ordinance, it states they must accept cash and debit cards. That is all.
Mr. Goldstein, go ahead.
I'd move to dismiss this or a judgment of acquittal as it's all hearsay. I've been able to cross-examine any complainant. I have no information on any complainant. I don't have any testimony, and there's been presented no testimony that anything that's been presented here was said.
Ms. Anderson, who is the complainant?
I don't have that information with me.
How did the county receive a complaint?
We received a complaint via our online complaint system.
Do you have a
The complaint
printout
was
or
then
any
sent to
indication where
Target
that
Towing.
complaint originated?
No?
Could you
Do we
repeat that,
have-
Doctor?
Yes, sir. Do we have anything that will advise where that complaint originated or who sent it?
I could look it up.
Okay.
Have anything with me? No, Your Honor.
Are you able to look it up while we're here right now?
Yes, Your Honor.
Okay.
Archives our emails after a certain time. I'm in the process.
Dr. Santoris.
Yes.
Okay. While we're waiting for her to find her stuff, just let me advise you as to the issues in this case that I've seen. Hearsay evidence is allowable to support a position or a violation, but hearsay cannot be used to prove a violation. So we need some type of signed statement from the original,
Complainant?
yes.
Okay. Thank you, sir.
Mhm.
Ms. Anderson, did you find anything?
She's working on it.
Okay.
on with another county email, though it would not allow me access.
You cut off. I didn't hear everything, Ms. Anderson.
The next case is involved with this as well. I'm unable to sign on to the computer. I would ask that I am allowed to bring this to the next month, if that's possible.
Is this in Permits Plus? Is the information in Permits Plus?
Some of it. The
ESR?
email. Yeah.
ESR, okay. Give me just a moment, because I think I can get that.
All right, so let me rule on Ms. Anderson's motion to continue, seeing that the alleged violator has retained counsel and being cost prohibitive for counsel to reappear again, motion to continue this case is denied.
Okay, thank you. The last page of this slide, the slideshow, is the email from Cal McFarland, but that's all I have, Your Honor.
Could we see it? Okay. And who is the person who sent this?
Mr. McFarland, he's the representative for Target Tow.
Okay. All right. Any further testimony on either side?
No, just renew the motion to dismiss.
No, Your
The
Honor.
motion to dismiss is granted. I rule that the contest be upheld and that this case be dismissed.
Case on page 3, item E, RCV 2028, citation 00668, issuance date February 14, 2020. The amount due is $50. The violator is Target Recovery Towing. The offense date was December 18, 2019. The prohibited conduct is failure to accept reasonable service fee for a vehicle that was in the process of being towed. The investigator is Cindy Anderson. And please, again, state your name and address for the record.
Jason Goldstein, 7601 38th Avenue North, St. Petersburg, Florida, 33710, attorney for the defendant.
Aaron Watkins, Target Recovery Towing, 381 Roberts Road, Oldsmar, Florida, 34677.
Dr. Centarlis, this is Paul
Cindy
Johnson. We have a
Anderson,
moment.
regulatory compliance.
Mr. Johnson, go ahead, sir.
Okay, Ms. Rodriguez, could you pull up the citation itself, please?
For this case that I just called?
Yes. Okay, Dr. Centarlis, in fairness to all parties involved here, I just needed to point out to you that Section 5180 of our ordinance requires compliance with state statutes 71507. In the citation itself, 715.07, subparagraph 3 in parentheses is cited. It should actually be 715.07, 2 in parentheses, A in parentheses, 3 period. Subparagraph 3 in parentheses is merely a paragraph saying that the statute is not applicable to law enforcement, fire rescue, and assorted vehicles. That saying, in quasi-judicial hearings, basic due process applies, and that is number one, basic due process is number one, notice. Number two, an opportunity to be heard. Obviously, they got an opportunity to be heard today at the hearing. Notice is notice of the violation. There is a slight error in the subparagraph cited to in 71507, but the wording of the citation itself, I just wanted to advise you that if you find that the wording and the testimony provided sufficient notice to uphold the violation, you can continue. If you believe that the citation and the testimony that we presented was not sufficient to provide proper notice to the alleged violator, it should be dismissed. I just wanted to bring that up in fairness to all parties because there is a slight error in the subparagraph cited to the statute.
Thank you, sir. Ms. Anderson, go ahead with your testimony, please.
While investigating the consumer complaint, it was found that the business failed to provide, oh, I'm sorry, that's the wrong one. It was found that the business failed to accept a reasonable service fee for a vehicle that was in the process of being towed. They came out while the vehicle was in the process of being towed, and they tried to pay a drop fee, though the driver would only accept cash. This is the same instance as the last case. The email from Mr. McFarland from Target RT Tow states that they would only accept cash.
How'd they try and pay?
Could you repeat that, sir?
How did they try to pay?
A debit card.
Okay. Okay. Anything further, Ms. Anderson?
No, Your Honor.
Okay. Mr. Goldstein, go ahead, sir.
I'd move to dismiss this case as well, as there is no complaint available for me to cross-examine. There's hearsay evidence as to a report or a online complaint that may have been filed, but I've not seen it, and I have no one to talk to and no one to question about this. So I would move to dismiss this case as well.
Ms. Anderson, is there a complainant available?
No, Your Honor, there is not. What I have is the response from Target Towing acknowledging the complaint, as well as telling me in 2 different paragraphs they would only accept cash.
Okay, so there's 2 issues on. The first one is a minor issue with the statute being incorrect. I believe there's sufficient notice provided, so that's not going to become into play. So due process is going to be checked off. They have an opportunity to be heard, but we're running into the same problem again. There's no proof of a complainant. I agree with you that there's an email here indicating that they're accepting cash only, but I feel there needs to be a complainant and that the county should have this information readily available. Sonia, are you able to find a complainant in this particular case to help Ms. Anderson?
No, sir, without the SR number, which is the service request number, I couldn't see that.
Okay. I think part of the due process to be heard is that defense counsel has an opportunity to cross-examine or to look at evidence that's being submitted by the county. And I know routinely when there's failure to appear with the defendant, that these cases are upheld based on the evidence and testimony that's supported by the county. Any further testimony on either side?
No, Your Honor.
No, Your Honor.
Okay. Mr. Goldstein, your motion to dismiss is granted. I rule that the contest be upheld and that this case be dismissed. And I believe that
We just have the
concludes our-
approval of the minutes?
Okay. Yep. I approve the minutes of the August 27th, 2020 hearing. And I believe that concludes everything on the agenda, correct?
Yes, it does. Thank you.
Yep. We're adjourned until, looks like, November 19th, 2020 at 9 a.m. Is that correct?
That is correct.
Okay. Thank you.